Hello dear friends, I, CACS Shweta Jain would like to wish you all a very good day. I hope you all have benefited from the first episode on Indian Contract Act 1872. Herewith, I am uploading second episode in the series featuring the Sales of Goods Act 1930. Let us start. The Sales of Goods Act 1930 deals with goods but not with other movable property or immovable property. For immovable property, we have Transfer of Property Act. The term goods mean every kind of movable property and includes stocks and shares, growing crops, grass and things agreed to be severed under the contract of sale but excludes actionable claims and money. But it includes antiques and rare coins. A contract of sales of goods includes both an agreement to sell or sale. Sale means immediately transferring the ownership and possession, while in agreement to sale we transfer the ownership or possession at a future date. The consideration for the contract of sale can be partly in money and partly in goods, since the Act does not prohibit as such. Essential elements of a contract of sale includes seller, buyer, goods, transfer of ownership, price, and essential elements of valid contract. To sum up, before 1st of July 1930, Sales of Goods Act was part of Indian Contract Act 1872. So a lot of places where the Act is silent, we take inference from Indian Contract Act 1872. The Sales of Goods Act does not apply to hire purchase agreements and contract for labor. There can be sale or agreement to sale in respect of existing goods, but there can only be an agreement to sell in respect of future goods and contingent goods. That is, availability of those goods depend upon some uncertain events. Those goods can be called as contingent goods. The contracting parties are not discharged on acquisition or non-production of future goods, but are discharged on non-acquisition of contingent goods. If goods are destroyed, the contract of sale or an agreement to sell specific goods becomes void, but contract of sale or an agreement to sell unascertained goods does not become void. While price is not determined in any manner, the buyer must pay the seller a reasonable price of goods. Reasonable price of goods is a question of fact which in case of dispute can be decided by the court of law. In case of sale, buyer gets jus in rem, that is, buyer as a owner gets full rights to enjoy the goods against all of the world. But when it comes to agreement to sell, buyer gets jus in personam, that is, a personal remedy against the seller. Stipulation as to time of payment is not deemed to be an essence of a contract of sale unless otherwise agreed. Stipulation can be a condition even if it is called as a warranty in the contract of sale. That is, a warranty can be a condition, but a condition cannot be a warranty. A stipulation, the breach of which gives the aggrieved party a right to terminate the contract, is called a condition. The breach of condition is treated as a breach of warranty where the contract is not served and the buyer has accepted the goods or part thereof. Conditions and warranties may be expressed or implied. As discussed earlier, stipulation can be made in two ways. First, conditions, which means the condition is essential to the main purpose of the contract. Second, warranties, it is collateral to the main purpose of the contract. In a contract of sale by description and by sample, the goods must correspond with the sample as well as description. In a contract of sale of goods, there is no implied condition or warranty as to the quality of the goods or their fitness for any particular purpose. A seller is not bound to disclose those defects of his goods to the buyer before sale which the buyer could have discovered if the buyer would have examined the goods. The rule of caveat emptor does not apply where the buyer has disclosed the purpose for which the goods are required and relied upon the seller's skills or judgment. I am discussing here with exceptions to the doctrine of caveat emptor. In case of misrepresentation by the seller, in case of concealment of latent defect where the seller knowingly conceals a defect which would not be discovered on a reasonable examination, in case of sale by description, in case of sale by sample, in case of sale by sample as well as description, fitness of a particular purpose where the seller or manufacturer is a dealer of the type of goods sold by him and the buyer has disclosed the purpose for which goods are required and relied upon the seller's skill or judgment. Condition as to merchantable quality means goods must be free from any latent defects and does not apply to defects which the buyer could have discovered if the buyer would have examined the goods. Passing of property means transfer of ownership and not only the physical possession. Ownership can be transferred only in case of specific or ascertained goods and not in case of unascertained goods, future goods or goods sent on approval. There is a thin line of difference between specific goods and ascertained goods. Specific goods are decided at the time of contract only, and in case of ascertained goods, the goods are segregated or decided after the time of formation of contract. In case of a contract for sale of specific goods not in deliverable state, the property in goods passes when the goods are put in a deliverable state and the buyer has notice thereof. When goods are sent on approval, the property in goods passes if the customer to whom goods were sent on approval also sends such approval to some third party because it amounts to adoption of transaction. In case of contract for sale of unascertained goods, the property in goods passes when the goods are ascertained and unconditionally appropriated by the seller / buyer with the consent of the other. The person whosoever be the owner at the time of occurrence of loss has to bear the loss even if delivery has not been made and price has not been paid. Following are the modes of delivery: actual delivery, that is where the goods are handed over by the seller to the buyer or his authorized agent; symbolic delivery. A classic example of symbolic delivery would be checks given in KBC. I am sure you all must have wondered about the size of the checks given. Next could be constructed delivery, that is the delivery when a third person in possession of the goods acknowledges to the hold of goods on behalf of the buyer. Where the seller has reserved the right of disposal of goods, the property in goods passes when the conditions imposed by the seller are fulfilled. The seller is deemed to have reserved the right of disposal of goods in case of goods deliverable to the orders of seller or his agent or drawing of bills of exchange for the price of goods and Sending bills of exchange with the document of title. Risk follows ownership. That is, as soon as the ownership is transferred by the seller to the buyer, the risk is also transferred. No seller of goods can transfer better title to the buyer of goods other than the himself who possesses such title. A seller in possession of goods under a voidable contract can pass a good title to a bona fide buyer before the contract is rescinded. A seller in possession of goods in the capacity of a bailee cannot pass a good title to a bona fide buyer. For a moment, let us talk about bailment. In case of bailment, possession of goods is transferred from the bailer to the bailee for some purpose, that is, for safe custody, maybe repair also. It requires only possession. The consideration for bailment may be gratuitous or non-gratuitous. For example, you borrowing your friend's car or a jeweler giving to his worker gold as a raw material. A joint owner in sole possession of goods with the consent of all other co-owners can pass a good title to a bona fide buyer. Where there is no contract as to the place of delivery of existing goods, the goods are to be delivered at the place at which goods are at the time of sale or an agreement to sale. Delivery means voluntary transfer of possession from one person to another. Delivery of the key of a warehouse where the goods were lying amounts to symbolic delivery. Where there is no contract as to the time of delivery, the goods are to be delivered within reasonable time. Unless otherwise agreed, there must be simultaneous payment of price and delivery of goods. Unless otherwise agreed upon, the buyer must apply for delivery because the seller is not bound to deliver the goods unless the buyer makes the demand. Unless otherwise agreed upon, the expenses of putting the goods into a deliverable state shall be borne by the seller. Also, the buyer is not bound to accept the delivery by installments if there is something else in the agreement. Delivery of part of goods with an intention of giving the delivery of the whole amounts to the delivery of whole of the goods. Where the seller delivers a quantity of goods larger than contracted for, the buyer may accept or reject the whole or accept the contracted quantity and reject the excess. In case of short or excess delivery, if the buyer rejects the whole quantity, the contract is not treated as cancelled. The seller still has the right to tender again the quantity of goods as per contract, and buyer is bound to accept the same. Delivery of the goods to the carrier, whether named by the buyer or not, for the purpose of transmission to the buyer, or delivery of the goods to a wharfinger custody is prima facie deemed to be a delivery of goods to the buyer. Now, let us talk about wharfinger, that is, owner or keeper of a wharf. The immediate next question would be, what is a wharf? A quayside area where ships are anchored for loading or unloading. Right of lien can be exercised when the goods have been sold without any stipulation to credit. Right of lien cannot be exercised where part delivery is intended as delivery of the whole. Right of lien can be exercised where the goods have been sold on credit but the term of credit has expired. Right of lien can be exercised where the buyer becomes insolvent. It can also be exercised if seller possesses the good as agent or bailee for the buyer. Right of lien can be exercised if seller has obtained a decree for the price of goods. Right of stoppage in transit is an extension of right of lien. Right of stoppage in transit can be exercised if the seller has parted with the possession of goods and goods are in the course of transit and the buyer has become insolvent. Goods are deemed to be in course of transit from the time when they are delivered to a carrier or other bailee for the purpose of transmission to the buyer until the buyer or his agent in that behalf takes delivery of them from such carrier or other bailee. Right of stoppage in transit can be exercised if the carrier holds the goods in the capacity of an independent person and not in the capacity of an agent for the seller or buyer. An unpaid seller is bound to resell the goods. The unpaid seller must give a notice of resale to the buyer irrespective of the nature of goods. Where the seller has expressly reserved the right of resale, the unpaid seller must give any notice of the resale to the buyer. Where a notice of resale has been given to the buyer and there is loss on resale, the unpaid seller can recover it from the buyer. If notice of resale is not given, the new buyer who buys in resale from unpaid seller will get a good title irrespective of the fact whether the notice of resale has been given to the original buyer or not. An auction sale can be subject to a reserve price. The relationship between the owner of the goods and the auctioneer is that of a principal and agent. In auction sale, a bid once given can be withdrawn before the fall of hammer. An auctioneer can refuse to accept even the highest bid. In an auction, bidder can enter into an agreement to keep the bid low by eliminating competition amongst them. A seller can reserve a right to bid at an auction. Where the right to bid at an auction is expressly reserved by the seller or anyone on his behalf may bid at the auction. A sale may be notified to be subject to a reserve or upset price. The reserve or upset price may be defined as the minimum price below which the auctioneer will not sell the goods put up for an auction. Above were the key points of Sales of Goods Act 1930. I hope you all have benefited from the previous episode and will continue to read and revise the same. Next time we meet when I upload the coming podcast on Indian Partnership Act 1932.